Okay, everybody, thank you very much for joining us today. We're on this very, very important topic. We're really excited to have Ellen, who is a mum of a son with NF1. Some of you may know her. She's amazing, as is her lovely son. And she's here today with her colleague, Malcolm Stoddart, and they're joining us to talk about some very important, but yeah, very necessary things to think about, planning issues. So let's get going, shall we? And we've got Meredith from CTF here as well. And I'm Ruth, we're the support coordinators. Any questions or any issues you have afterwards you'd like to discuss with us, please just let us know, get in contact. Otherwise, let's get on with it. Thanks, Ellen and Malcolm.
Thank you, everyone. Like I said, my name is Ellen and I'm an NF1 mum, and Malcolm here is my wonderful colleague who works with me at Owen Hodge Lawyers. Firstly, we both wanted to thank CTF for giving us this platform to have a chat with you all, because there's nothing more vital than getting your estate planning affairs in order. Because of my son's condition, it's without a doubt, it's vital to have all these in order. I know we don't want to talk about death. I know we don't want to talk about if anything happens to us, but the reality is, it's going to happen. So it's best to be educated about it all and just know what your options are available. So thanks CTF for allowing us this platform. So Malcolm stole me from a little law firm in the suburbs, and he's a wonderful practitioner. He's absolutely delightful. And he has been practicing since 1974. He's in a loving relationship with Satish for over 10 years. He has 4 adult children and 9 grandchildren. He's also a Virgo, and also he's turning 70 in a couple of days. And he is just absolutely wonderful. So thank you, Mel, for doing this for us. Myself, I've only fairly new in the industry in respect of being a solicitor, so I'm 5 years. That's still considered fairly on the cusp of junior, senior solicitor. But I have been in the industry since 2005, so I've seen my fair deal of estate falls and everything else. So my main focus with Malcolm is deceased estate administration, estate litigation, estate planning. So we deal with all that. I'm in a blended relationship with my partner, Jason. His daughter, Christina, also lives with us. And then obviously Emma lives with us as well, who has NF1. He was diagnosed around 3 months old. And in about 2011, we found a substantial size plexiform tumour in his neck, which, like you would all understand, that constantly needs monitoring. So thankfully it's all stable. And he's fine otherwise. So we just got to watch and wait. So hopefully nothing ever happens. It is what it is, right? So estate planning, there's a will, there's a way. Why is it so important? How do wills work? How do enduring powers of attorney work? How do enduring guardians work? And Malcolm will be giving us an overview of special disability trusts as well. So essentially, power of attorney, wills, enduring guardian, and special disability trust form estate planning. So I'll be going through wills, enduring power of attorney, and enduring guardian, where Mal will be dealing with the special disability trust. So real life examples, if you are separated and not yet divorced, you need a will. Is there property settlements to consider and things like that? Definitely need to talk to estate planning solicitors. What about if you're divorced? What about if there's stepchildren? Again, you need to talk to us again. What about if you don't have any family or no children? You have to talk to us again. There was a scenario I was telling the ladies just before the webinar started, where I met elderly clients in their 80s and they were caring for their son's 6 children who were all under 15 years old. Their child was unable to care for his children, and they were in their 80s caring for their children. One of them had cerebral palsy, and you can just imagine the stress they were going through, just trying to get their affairs in order. Who's going to look after them? Who's going to maintain and care for them? What happens if you have your spouse pass away unexpectedly? What happens then? What about if you're unable to make decisions for yourself? Who's going to make decisions? What about if the kids don't get on and hate each other's guts and then use you as the medium to get it back at each other? These are things that can certainly be, put on hold, stopped and controlled, or if we know what we're doing. So come chat to us about that. So real life examples, who will care for your children, your NF children, if that, if you're unable? Again, estate planning falls into that. If you pass away, what assets will pass to your children? What about if they don't have capacity? Who will take care of them? Where will the assets go? These are questions we can certainly help you with. Now, I don't know if you remember this young lady who passed away in 2018. She was in the car with her family and they all died. Then, I sit back and go, I hope she had her estate planning in order, because the whole family just went. So again, estate planning, why it's important. You can control how you're taken care of, others how they're taken care of. Pets, we always have to watch out for our pets. Assets, where do they go, even while you're alive or where you're passing. Gifts to Children's Tumour Foundation, and obviously asset protection. So we can assist with that as well. Now, Steve Irwin, we remember him, he passed away suddenly. Now, let's hope for the zoo, Australia Zoo, let's hope he had his estate planning in order. He's another one that was unexpected as well. Now, I just did some research. Now, this young Walid from the project, they've got an autistic child. They would need estate planning. You got the NF1 brothers from, I think his name is Adam Pearson. They're twin brothers. So they both have NF1, but we also know how different NF can be and how it can affect people. So, and what I found really interesting was this young girl that was a Harry Potter star in one of the movies. Her daughter has NF1, has had a substantial tumour in her brain, which I wasn't aware of. And so definitely, NF doesn't discriminate. It touches everyone. So how does an enduring power of attorney work? Enduring power of attorney is a legal document that deals purely with your financial assets. It can be limited to control what assets are controlled and dealt with, but keep in mind, an enduring power of attorney only deals with your assets while you're alive. So that is the main point. It is a very powerful document. It can buy and sell property. Now, I had a situation where I had a gentleman who had his estate planning affairs dealt with prior to him years later having dementia. He won lotto, substantial amount of money, and thankfully with the help of his family, and because he had these documents in order, they could help him. In one scenario, he actually gave away $10,000 to a complete stranger in the city. So it's definitely, you need to get these documents.
Sounds like a movie, doesn't it?
It does, and God bless him, he just saw a lady, he thought she was lovely and bought her a watch and $10,000. So, right place, right time, I guess, but not good for him. The enduring guardian, another document that only works.
Thank you so much. Bye.
Sorry, I could hear someone there. An enduring guardian is a legal document as well that deals predominantly only with your health during your lifetime. That can manage where you live, what health care you receive, personal services you receive, and any medical and dental treatment you receive. And it also can dictate in there, if there is no likelihood of recovery, then not to subject you to medical intervention. So it is a document that you need to be transparent with the people that you nominate to make decisions for you. Tell them how you want things done. And this document puts it in black and white to make sure you control what happens there when it comes to if you're unable to look after yourself. I've had situations where, blended families, de facto relationship, and, the children come in and say, no, you've never been part of my father and mother's life. And thank God some people have these documents and others don't. So it's sad it comes that way, but unfortunately, Malcolm and I see this all the time. Okay, your will. So your will only becomes effective upon your passing, but of course it needs to be dealt with while you're alive, granted. It can deal with all your assets, including your house, your cars, your shares, who will take care of your children, your pets, whether you wish to be buried or cremated, and it could also consider your superannuation if you wanted it there. So that is a separate beast, but we won't be talking about that today. So like I said, your will is only effective on your death. I've got I think being a Greek background, I'm very much of the view of the only people that should know what's in your will is the people that you've nominated as executors, who are the people who manage your will once you pass away in your estate. But that's a personal preference. Some families are happy to hand out their wills to everyone, but that's certainly personal discretion. Anything you wanted to add there, Mel? No? So I'm just going through a timeline because a lot of people get confused on how everything works. So like I said, once you come and see us with estate planning, we will look at your options and your situation. Are you in a blended family? Are you married? Are you in de facto? How many children? Are there stepchildren? Are there half siblings? Are there no children? Do you want to give to a charity? All these things we will definitely consider and tailor something for you. From that point, you would then have an enduring guardian and power of attorney that will work during your lifetime only. So like I say to everyone, once you pass away, these documents pass away with you. When you do pass away, your will then becomes effective. So just keep that in mind. A lot of people do get confused as to how these documents work. I will say this, whoever you nominate to care for you during your lifetime doesn't need to be the same people that manage everything in your will. So depending on your circumstances, depending on your assets and things like that, there may be different people involved. So it doesn't need to be the same person all the time or people. So what happens if we have someone who does not have capacity? So for us, we don't look at a health situation and assess them in people with capacity in that way. We have legal requisites. Banks and Goodfellow is our primary case that we have to rely on to confirm whether someone has ability to give instructions for these documents.
From
1870, that's right. So it's old law, but it's good law, and it keeps being used all the time. Now, with respect to, let's say we have, I've been involved in situations where a child has been in a major car accident, has received huge amount of compensation. So if the child is unable and has brain damage to deal with their assets, who deals with it then? What about if the parents are divorced? Where would the child's assets go then? So in a particular case that I'm aware of, a child receives a substantial amount of money from compensation, unable to make a will for himself or make documents for himself. So therefore the lawyers can step in and assist the family with a statutory will to make sure the money goes where it should go after he passes away. There's also NCAT, which is a tribunal in New South Wales. I know obviously other states do have similar tribunals where if someone's just beyond the point where they have absolute no capacity or there's a dispute, NCAT will then step in. You can seek an application, which that's something Malcolm and I don't want normally to happen for people.
don't like it.
We don't like it. So that was a polite way of saying it, but it's certainly it is an option, but hopefully you don't have to go there because hopefully we can organise everything fine. So, and then there's special disability trusts for the family members who do not have the ability. I know for us, we've got a situation where a gentleman was schizophrenic and his father bought him a house under a special disability trust for him to live in. So at least he had a roof over his head. So there's certain ways that solicitors can step in that regard. So on to you, Mal.
Yeah, well, I'm going to discuss special disability trusts and their relevance for NF families. And I do want to say, don't be frightened. This is a moderately complex area of the law, but if you're dealing with a solicitor who knows very well about them, it's just another part of the estate planning process. And I'm going back 30 odd years or so ago before we had these special disability trust wills, when I actually drafted some from scratch for people, and people would come in and say, who will care for my child when I die and or when I'm gone? And as when you get to your 70s or 80s with a disabled child who's perhaps living with you still, that is a huge burden to bear. But today, with the Commonwealth Government and Centrelink, there are great things you can do. However, I just want to introduce you to a late friend of mine, the late Associate Professor, the Reverend Canon Dr. Christopher Newell. Himself, he was profoundly disabled, but he had a doctorate and a associate professorship. But he used to say, and he worked with lots of disabled people, there is no such person as a disabled person. There is a person with a disability. And I think if you've got someone disabled in your family, that is a good way to think of them, because, you know, even profoundly disabled people have their own quirks and potential, shall we say. There are two forms of a special disability trust. Now, these trusts are drafted originally by a extremely excellent estate planning lawyer from Melbourne, Mr. Alan Swan, and they've been gradually improved over the years. And you can set up a special disability trust in your will, or what the law calls in Latin, inter vivos, while you're still living. But, and of course, there are many, many scenarios, and we can't go into all of them today. I can send you this screenshot if you email me, or a longer one. But the trust fund can have the housing, the house, a strata titled unit on the 18th floor, gee, I'm losing my memory. No, yes, I have. It could be in a nursing home, whatever. So the trust can remain valid, allowing full benefits with the housing, whatever it may be, a house, a unit, a nursing home apartment, plus $694,000. Now, I'll come back to that in a minute. The Special Disability Trust, firstly, when you come and see us or another lawyer that specialises in these, you have to realise that it's an estate plan for your disabled child within your estate plan. And a little minute or two, I'll give you some real life examples that will follow. There are many thousands of them, and I've done dozens and dozens of these documents, and they're all different. But to benefit from a special disability trust, your beneficiary must be severely disabled, must be aged 16 years of age and over. The impairment would qualify him or her for a disability support pension or a pension from the Department of Veterans Affairs. That beneficiary has a disability that would, if the person as a sole carer, would qualify the carer for carer payment or carer allowance. So you can start to see it's getting a little bit complex, so don't try and think it all through this today. They could be someone living in an institution, hostel or group home in which disabled care is provided. And in fact, the very first disability trust I set up 40 odd years ago, 35 years ago, was for a young woman. And ultimately when her mother died, the proceeds of the trust went to set up a group home for a number of young disabled people. And the disabled person must not work more than 7 hours per week. Now, you may want to check that. That may have changed. What can the trust income be spent on? The Commonwealth Government has loosened the hold on expenditure. So the trust can undertake a level of discretionary spending that is not directly related to the care and accommodation needs of the beneficiary, as long as the spending is for the benefit of the beneficiary and the beneficiary alone. The limit was set up in $10,000 in 2011, and it was increased in 2020 to $12,500. Examples of what the trust can pay from the discretionary amount, that is the $12,500, certain foods, household items, toiletries, does he or she want opium or I don't mean the drug, I mean the perfume. Or Calvin Klein, vehicle maintenance if they have a car, vehicle registration, vehicle insurance, petrol for going for a run, recreation and leisure, a computer, and a heap of other things such as therapy and household cleaning. You can read about that on the web pages in the Commonwealth Government. The Commonwealth Government has further loosened the stranglehold. It used to be very, very tight how you could spend the fund. But now, from the 1st of July 2006, there was a capital gains tax exemption for assets donated to the Special Disability Trust. It also allowed capital gains tax exemption for the recipient of the beneficiary's main residence if disposed of within 2 years of the beneficiary's death. And the government also ensured equivalent taxation treatment among special disability trusts established under different acts. So it is a little bit complex, but nothing a good lawyer can't walk you through. Further loosening in the 1st of July 2008, unexpended income of a special disability trust is now taxed at the beneficiary's personal income tax rates rather than the highest marginal tax rate, which was, from memory, 48.5 cents on the dollar. And from the 1st of January 2011, a beneficiary of a SDT can work up to 7 hours a week at or above the relevant minimum wage. Rob and Alison, they were in their 50s. They had a house valued at $750,000 at Dapto on the south coast. They had some limited superannuation and even more limited investments, but they did have 2 severely autistic sons. So yes, the sons qualified for a special disability trust, and we made the testamentary trust will with the trusts for them, and they worked very effectively. Antoinette's story, I remember this one well. She was on a disability pension and in her early 60s. She was living in public housing in the inner west. She received a will gift from her mother's estate of $600,000, which was going to completely muck up her pension. She was already in remission from severe drug addiction, but she suffered from agoraphobia. So that meant she was often scared to leave her home. I met her in a local cafe where she was prepared to come and talk to me. She fortunately had a caring sister, a not so caring or helpful psychiatrist, and the reports and applications were not in good shape. But we got them right, and she was finally assessed as an SDDT recipient. I'll tell you the benefits of that soon. Herbert and Hillary, both in their early 80s, they had an estate of 21 million, and this was about 10 years ago, so I hate to think what it's worth today if they're still alive. Anthony, their son, suffered from moderately to moderately severe Down syndrome and was their very much loved only son. They also had 2 daughters who both loved their brother. Hillary was always thinking about what will happen to Anthony when we are gone. How could they structure their plan? Well, I'm not going to go into the detail, I could, but we spent a considerable amount of time with them working out a good plan. And with so much money, they could do any number of things, but we worked out a plan that worked. One of the things we did with Hillary and Herbert, or whoever it was that we had a number of family conferences, including the daughter who was going to look after Anthony when both parents died or got too severely ill to look after him. We prepared a statement of wishes. What is a statement of wishes? Well, it could be a Section 100 declaration by way of evidence as to the post-death appointment of a guardian or alternative guardian.
So really don't fear seeing us. We're here to help. We certainly have experience, not only personally but professionally, dealing with so many different matters. We could, a lot of people tell me we can write a book, and that can easily be done.
We probably should.
We probably should write a book. So, look, nothing to be ashamed of. It's a lot of people come and visit me and say, you know, they're worried to come and visit an estate lawyer because they think they're going to die. Touch wood, I haven't had that yet, so you're safe.
But I have had, especially some professional clients who have never told others of the disability of their child, and coming and seeing me about setting up this special disability trust has basically released them to talk about it and bring him into the wider, or it was a her in this case, into the wider community, which was marvellous.
So, like I said, what's the benefits of coming to see Malcolm and I? We always wish for you to live 110 years old, and hopefully you pass away peacefully in your bed and have all your faculties until then. We always pray for you in that regard. Like I said, we have experience and can provide you with different options that you may not consider for yourselves. We make it easy, and it is a very simple process. And most importantly, we are wonderful. That's just the fact. So,
Well, I think you people on the other end of the screen are wonderful for
absolutely
bringing up your beautiful children.
That's right. Absolutely. So, look, any questions, please feel free. I cannot see comments made during our little webinar, but Ruth?
I think it's been quite quiet. They've been busy listening, Ellen.
Oh, okay.
If anybody wants to, well, you can unmute yourself or you can type in the questions in the chat function. So does anybody have anything they want to ask? Anybody? Will we send a copy of the slides? That's up to that. That's a very good question. That's up to Ellen and
Definitely can. And,
Malcolm. Yes, we can.
And if you want to get further in contact with me, just send either of us an email, and I can send you the longer version, which gives other illustrations of the Special Disability Trust. I believe that they are an amazing. I go back to 35 or more years ago when I had to draft them from scratch with no statutory backup, and now we have all these amazing government-supported abilities to do these trust wills, backed up by the Commonwealth Government and Centrelink.
So you're all able to unmute yourself now if you do want to ask any questions. Anybody have any further questions?
Don't be shy.
And that means you must have done a really good job, Malcolm and Ellen. Hang on, there we go. I can send you, Marta, I can send the, Marta's just asked what's the best contact details.
I'll send an email at the end and just introduce myself and just, sometimes, obviously, people, it's very private, and look, we certainly, it doesn't go beyond these walls, and we'll just walk through your options available.
Yeah, I think that probably does limit people. We are recording this at the moment, so yeah. But if there's any general questions that people have, we've got one down here. I
should make a note actually. We're situated in New South Wales, and I can go to really anywhere in in Sydney, I should say. But in saying that, I know we've got a few Victorians.
Yes, but these are federal documents, so they can be drafted for anyone.
We can certainly assist in that regard. So if you're in Victoria or Adelaide, wherever you're coming from, we can certainly assist you.
So that answers Anne's question that she's
going to say,
in the chat. Anne's from the ACT and wants to know if she can make a will using a New South Wales-based lawyer. So obviously, yes. Another question's just popped up. What are the costs involved, Ellen?
So it depends. That brings us on to our next slide. So in the month of September, I have sweet talked Malcolm here to share, to lose some of his profits when it comes to our estate planning. So if we do estate planning, we anyone that has Children's Tumours Foundation as a code word, we're actually providing 20% of our fees to Children's Tumour Foundation for the month of September. So how that will work is we will do an initial consult with you, which will require $50. That goes directly to Children's Tumour Foundation, and you'll get a receipt in that regard. If we do prepare the documents, then 20% less our fees will then go to Children's Tumour Foundation as well. So it really depends on, I can't say what our fees are, because it really depends on what you're doing. If you're in a situation really basic, your wills and things like that, it will be different to a special disability trust. So really it's tailor-made to everyone. So it's not a one shoe fits all scenario. So if it's very complicated, of course it costs a little bit more, but keep in mind in the month of September, we're going to be providing Children's Tumour Foundation with the gifts as well.
And can I say that normally they cost somewhere between $4,500 and $5,000. It sounds a lot of money, but depending on the assets people have, and I have a soft spot. And, I often do them much less.
So that's why he's wonderful. So it's certainly we are big softies, and we're very big on assisting people when we can, and that's why I've reached out to Children's Tumour Foundation and finally have an avenue to help everyone out. Any other questions?
We have, is that, Renee was just wondering, is that a will or a special disability trust? Is that the cost? I think she's wondering.
It's two wills, presuming that most people are usually in a relationship, but they may not be, which would make it cheaper. And it would be powers of attorney, guardianship documents, and probably an advanced healthcare directive, subject to what state people are living in.
And could you tell us a bit more about the advanced care directives?
Yeah, these are, there was a case in New South Wales, 2006, in the matter of A and Hunter and New England Health, where basically a fellow had been on dialysis for months and months and months, if not a year or more. And he was basically close to death. And one of his friends found a piece of paper in his wallet. It wasn't even signed, where he said that in these last times he wanted to be taken off all dialysis. The hospital weren't sure if they could do it because they weren't sure whether or not they would be guilty of manslaughter or something similar. So they went to the Supreme Court, and the Supreme Court Justice gave an amazing decision, basically saying that Mal Stoddart, Ellen, Mr. A, whoever they are, can in advance dictate or tell the treatment they want. And it applies when you lose cognition. And a year or two later, there was a case in Western Australia, which I've got to forget the name, I should remember, where a youngish bloke in his early 40s had been a total quadriplegic. In fact, he could only communicate by the blink of an eye, a bit like that Parisian film. And he had just been saying for years that he just wanted to be allowed to pass away. And the hospital took his case to the West Australian Supreme Court. They provided a few more safeguards, namely extra medical opinion, but he was taken off his life support. He was allowed to just peacefully die over less than a week. So this is not euthanasia. This is what our Supreme Court, the New South Wales Supreme Court, calls dying naturally.
That's what I explain to my clients as well, because obviously a lot of children get really upset talking about mum and dad and when they're going to pass away and how to manage things. And I just say to them, well, think of it this way. The decision's already been made for you, just following through on those wishes. And it's just there in black and white just to make it easier for you. So then you can focus on mum or dad or whoever you're caring for. So that's why it's just vital. We've seen matters where people do not have these affairs in order. They go to NCAT and the kids are fighting like cats and dogs. And the person's stuck in hospital for a year trying to just deal with the scenario. I've got one too. So it's certainly, you know, it's something no one wants to talk about, but it has to be spoken, and you need to be transparent about. how you want things to go. I know, you know, how you want your body to be dealt with. Again, a lot of people don't like talking about it. I know there's a company that deals with fireworks, so they cremate you and put your ashes in fireworks, so then you can go that way. And I think that's a probably wonderful experience.
So the ones that are left.
The ones that are left.
Yeah.
But I think, Malcolm, we've also spoken about what you want in your funeral, whereas I haven't decided yet. But I do have a statement.
Yeah, I'm a lot older.
Age doesn't discriminate age.
No.
So that's certainly something that you know, Steve Irwin, you know, and that young girl from Home and Away. So definitely get your affairs and we'll have the conversation how you want to be dealt with while you're alive upon your passing. If fireworks drop, and I can send you a card as well. So that I think I'm blown away by that idea. So
Quite literally.
We've got another question here. Is there a way to have informal guardianship for an adult son and granddaughter?
What's it again? Sorry.
Is there a way to have informal guardianship for adult son and granddaughter?
it would really depend on the relationship of the adult son. Is he married? Is he in a de facto relationship? Who's caring for the child as well? Who else is involved? And that's why these documents are in order, because you might be married, but you might not want your husband or your wife to make decisions when it comes to your health. That's why these documents are important. I know situations where there's domestic violence and the husband is in fear of his wife, so he prepares these documents to make sure that his wife doesn't make decisions for him. So it certainly depends on the structure, and that's why we say it's tailor-made, because we need to understand the whole picture of what's going on in your life.
Yeah, us humans are very complicated. That is
always is.
That's right. We're lucky to have lawyers like you, caring lawyers like you. So thank you. And the CTF really appreciates your donations in the month of September for our NF Hero Month. That's incredibly generous. I know I will be coming to see you. So it's really great. We've got another question. How long does the consult go for? So if you come for a $50 consult, how long? What's the? How would that go?
30 to 45 minutes.
Yes.
And then another 45 minutes to sign everything up. So
I would say this as well. We can also, because we are in Sydney, because there's COVID, we can also do conferences via Zoom, telephone. So that's not an issue either.
Yeah, great. And you do cover all of Australia. So that's, yeah.
Yes.
Good.
The other thing is too, I should keep in mind, now obviously Owen Hodge is a larger firm. So how many lawyers do we have? I think we've got about 15 or 20.
Or more, 25, I think.
So please make sure if you ring our number to speak, ask them to speak to me and just say you're an NF Hero. And I've already explained to the girls what's going on. They already know what the situation is. But if you go to another lawyer, you won't get the discounts like you will with us as well. And they're not all estate lawyers either. So.
Okay.
Great.
Thank you very much.
Great. Hang on. We've got, oh, yes, we will follow up with all these details. Any other questions from anyone? No?
You've done pretty well.
I think we've covered quite a lot today. Thank you. I know I've learned a lot, and I really appreciate your time.
Panic. A lot of people, the information we provide, people panic and worry and just go, oh, don't, just take the time. Not too long time, but, you know, reach out to us and we'll walk you through everything again. We'll explain it again. So no question's a silly question is what I really want to get out there.
Especially when it comes to planning these important things. I think that's, yeah, it's worth taking the time just to have conversations. That's what's important in this. Well, thank you, everybody. I think that's it for today. We really appreciate you all coming along. And there's Ellen and Malcolm's details, but you can also contact us and we will send out their details at the end to everyone. And really, really appreciate you taking the time to join us today. So thank you.
Thank you for the platform.
Thank you for listening to us.
It was our pleasure. Thank you very much. I think we all enjoyed it.
Thank you.
Make sure you wear your capes.
Thanks a lot.
Ellen.
Bye.
Thanks,
Bye.
Malcolm. Bye-bye.
Bye.